Welcome back, ladies and gentlemen, to the Exceptional Conservative Show, live from the nation's capital. We certainly are not ashamed of the good news conservatism. What is the power of liberation? First the Republican and then the socialist. We have with us on this particular week, I want everyone to understand that this is a Pacific Legal Foundation week here on the Exceptional Conservative Show. Monday, Tuesday, and Wednesday, we have great guests from the Pacific Legal Foundation. They are defending liberty and justice for all. They are superior representatives of the American people at the U.S. Supreme Court. Tonight we have with us attorney Tommy Berry, who's with the Pacific Legal Foundation. You can find them at pacificlegal.org, pacificlegal.org. I want to come to you right now, Tommy, and want to prepare you for the question that I'm going to ask. It's about separation of powers. And I'm quite certain our founding fathers intended the Congress to act a certain way, the executive office to act a certain way, and the Supreme Court to act a certain way. If you could educate those who are listening tonight, what was the ideal way that our founding fathers understood in a federal constitutional republic, federated constitutional republic, how each of the branches of government should work? And then if you could explain to us, where did we go off the rail?
That's a great question. Thank you. I think the place to start, I don't think it's a coincidence that the Constitution's Article 1 is the legislative branch, because that was, in the original scheme, considered the most important branch, as it was the only branch that was supposed to be making policy, to be making the hard decisions that weigh the interests of different parts of the country and take responsibility for setting nationwide policy. And the Constitution explicitly says all legislative power herein granted shall be vested in a Congress of the United States. And the crucial element of that statement is the phrase legislative power. That's not apply to everyone that are written down so that people know what's forbidden and what's allowed. And that was considered the most important element of the rule of law, because if all law came from one specific body that wrote it down and then had no further role to play in its enforcement, that was seen as the safest method to avoid tyranny, to avoid having the same person both make the law and enforce it, in which case you run the risk of that person essentially doing whatever they want for their own benefit, or doing whatever they want without debate or without others checking them. The executive branch was tasked with simply enforcing the law, so it was not originally seen as a policy-making branch. Apart from the president's veto, which is the one element in which the president can have a substantive say on policy, the executive branch was simply supposed to take care that all laws are faithfully executed. And that word faithfully is reminiscent of, for example, someone executing a will or someone executing a trust. What that means is it's not supposed to be about what the executive thinks the law should be. It's about the executive as a faithful agent of the legislative branch. And then finally, the judiciary was set up and explicitly limited to cases or controversies. So the easiest distinction I like to put it is that the legislature is about before things happen, and the courts are about after things happen. The legislature says, here's the general rule written down. Then you have a close call where someone does something. Did that violate it or not? And then you go to the courts, a separate body, which is again supposed to simply faithfully interpret that law and apply the words simply as they were written, because those are the only words that people knew they had to follow.
Mm-hmm. The Mary Brockman, my bouncer in chief in the chat room here at TCN TV, has a question, and it goes to the explanation that you've given, which is a truly great insincere explanation of what the role and responsibility of each of those particular institutions separated as powers based on the Constitution, Article 1, 2, and 3. Her question is, why does the Supreme Court feel that it has the power to make law?
That's a very short but very deep question. I would say it's a little bit the Supreme Court's fault and a little bit Congress's fault. And what I mean by that is Congress has more and more found it tempting to write vague laws that simply have too many gaps in them, because that's a lot easier to pass politically. It's hard to get things through the House and the Senate and the president, especially if they're not all controlled by the same party. And so Congress will, for example, use a word like reasonable or compelling government interest or similar standards. And when they do that, they put the courts in a difficult position, because they put the Supreme Court in a position to, I think, be making policy decisions. I think the better course would be if Congress legislated much more specifically, and then you didn't have it passing the buck in that way. But the second element, and the way in which it's also the Supreme Court's fault, is that there are a few vague constitutional provisions, most famous or infamous, the Due Process Clause, that the Supreme Court, that is open to a lot of interpretation, but that especially starting in the 60s and 70s, the Supreme Court started interpreting in a way that wasn't connected to the historical meaning of those words and the rights that they were understood to encompass by the framing generation. And when they do that, they're essentially, again, making decisions based on what's the best policy, not based on what those words meant at the time the Constitution was enacted, which is not the role that the court is supposed to play.
And so, do you and do the people at the wonderful foundation, Pacific Legal Foundation, do you believe that the words of the Constitution are progressive and basically should be considered based on the modern interpretation, or should we always go back and take a look at what the founding fathers intended? I'm quite certain that they never imagined that we would have airplanes flying at their day in time. I don't know, maybe they did. But is their knowledge or their understanding of the law, because of their time period, weakened versus the intellect and knowledge base and the wisdom of a modern interpretation of the Constitution?
It's a very deep and difficult question. So one distinction, which a lot of people skim over, but is actually quite important, is the difference on whether you are looking at the original intent of the framers, so the 100 or so men at the Constitutional Convention, or are you looking at the original public meaning of the words that they wrote as they were understood by the general public? And the reason why those might be different is that a lot of scholars, and I disagree, and I agree with them, think it's not really possible to discern one singular intent when a large group of people write a document like the Constitution. I think if we're being honest, just that the framing generation was no different from ours. There were people of different ideologies. There were compromises. The language that passed through was the language everyone could agree on, but there may well have been differing intents of how much, for example, how strong people wanted those protections to go. So I think, but I do think the correct interpretation is what were those words understood to mean by the public, because that's essentially the only way to give deference to the checks and balances that say we agreed in the Constitutional Convention in the ratification by the 13 states to this language, not to anything else. And if you change the language to its modern meaning, that's illegitimate as well, because we did not agree to. Here's a easy but example that makes it better to understand. There's a phrase in the original Constitution called domestic violence, and if you read that in context, it says that the federal government can protect states from domestic violence. It was talking about insurrections. Now that term means, abuse within the home. It would be amending the Constitution. It would be unfaithful to the democratic process to say, well, now domestic violence means abuse within the home, so now we have to give it that the meaning has changed. That's if you want to change the meaning of the Constitution, you have to go through the amending process.
We're having a great discussion this particular evening, a great intellectual enlightenment, especially for those who happen to be on the left, in terms of the roles and responsibility of the separated powers of governance. And we're going to take a look at a specific case now, in which there is an overstepping of bounds by the government. And I'm quite certain that attorney Tommy Berry, who is with the Pacific Legal Foundation, pacificlegal.org, a wonderful institution that defends us in the Supreme Court. They've won 12 cases at the Supreme Court, which is amazing. They defend liberty and justice for all of us. And we're going to be looking at a specific case regarding clean water. Now, Tommy, I'm quite certain that all of us want clean water. Water is necessary for human life existence. And the pollution of it would cause duress in terms of there being a humanity. Of course, we want clean water. What is the role of government, legislative, executive, and judicial, when it comes to the whole idea of the federal government involving itself in keeping America's water clean?
Yes, exactly. So the case that's coming up on Wednesday, and for any viewers who are in the DC area, I'd encourage them, if they haven't tried it before, to get in line and go to the Supreme Court and watch it. It's a fun experience. You get to wake up early, camp out at about 5 a.m., but if you're in the first 50 in line, anyone can get in. So that's why this is a timely discussion. It's called to them, but they have to accept them, and then they enact that regulation. What happens when even that regulation they've enacted has an ambiguity in it, and it goes to court over that ambiguity? What we meant to say was this or that. And crucially, they don't have to go through notice and comment. They don't have to tell people in any kind of public way that that was their interpretation the whole time. They can literally, while a case is in this, and as long as that's within the realm of reason, the court has to accept it, even if the court would have interpreted the regulation another way. And that has had enormous consequences for interpretation of the Clean Water Act and the various regulations promulgated under it. That's why Pacific Legal Foundation is especially interested in this case, because we have litigated several cases about the Clean Water Act, where at the last possible moment, the agency in question has sent a letter saying, for example, oh, this little pond or a little depression that fills with water once every 50 years, that's actually a water of the U.S. That's subject to our regulation. Or, for example, land that's dry on top, but that has groundwater going 20 feet underneath it, or sometimes has groundwater going underneath it. They will write a letter to the court saying, yes, we think that that's now water of the U.S. So it's really not about, the principle here is not about how much we're regulating, as you said, the proper role or the proper balance of regulating the environment. It's really about making the government go through the proper procedure and about telling people in advance what the rules are and not simply getting a get out of jail free card at the last possible moment that can overrule the judicial branch.
We're coming to the end, and I know that there's a delay, so I'm going to ask two questions to you. One regarding the case law, and then secondly, how people can support Pacific Legal Foundation, because you all do a tremendous job representing Americans at the Supreme Court. But regarding the case law, what is the role of the swamp? Forgive me, the bureaucracy. Has it gone too far? And what can Congress do to limit the bureaucracy?
It's a good question. I think that the Congress has several options if they wanted to get serious that could rein in the bureaucracy quite a bit. In the 90s, they made a good first start called the Congressional Review Act that requires every regulation, every document with the force of law issued by a bureaucrat to be sent to Congress for their review. And Congress, if they don't like it, the House and the Senate and the President all agree they don't like it, that regulation is repealed. Unfortunately, that doesn't happen that often. It mostly happens right when one party goes out of power and the next party comes in. But there are proposals now that I think would be the best of all possible worlds that essentially reverses that burden, that says anytime an agency wants to propose a regulation, they can draft it, but they can't put it in power. Congress has to be the ones that put in power. And that really, I think, emphasizes the importance, which is that the bureaucracy defends itself as the only holder of expertise. They say we can't have Congress writing every little minute law because they're generalists. They don't have the expertise of a lifelong person at the Environmental Protection Agency. But the answer to that is it's perfectly fine for the experts to propose legislation, to draft it, to explain their reasoning as best they can. But the only people who have been vested with the legislative power to put that into effect is the legislative branch. So that's whether I don't think that's close on the horizon. I think more immediately it's up to judges by reining in this deference and also reining in the extent to which legislatures are allowed to be extremely vague. I think that's the first step, but in the long run, Congress has a role to play as well. As to your second step, as I said, people should go to pacificlegal.org. They can support us simply by sharing the stories of our clients on social media, on Facebook and Twitter, and telling their friends about us. They can aid us if they happen to know anyone who has been harmed by regulation, pass their story on to us. Or if they know of any laws where they're like, this just doesn't seem right, pass those on to us as well. And then if they're feeling generous, obviously, we run on the donations of our supporters, of people who agree with what we're trying to do.
Thomas Berry, this would not be the last time you come on TECN TV. I am very thankful for the work that you do and have done for Pacific Legal Foundation and how you represent us and keep us safe from all hurt, harm, and danger brought to us by an overly aggressive federal government. And I am praying that the good people would find a way to support the Pacific Legal Foundation. If you want to be a donor, get in contact with Pacific Legal Foundation at pacificlegal.org. Tommy, thank you for being the first of our guests this week, and we look forward to making this a very special and great week for Pacific Legal Foundation. God bless you. Have a very, very wonderful night. Ladies and gentlemen, we'll be back with more of the best at Urban Conservative Talk right after these messages.